All rise. The Court of Appeals, Division 1, is now in session.
Thank you. Please be seated. We're here today on CV140540, United Phoenix Firefighters Association, Local 493 versus the City of Phoenix. Each side will have 20 minutes to argue their case. Appellant, you may reserve any portion of that time for a rebuttal, but you'll have to keep track of that time yourself. We are recording this argument both on audio and video, so please identify yourself and your client when you begin your argument. In a few days, the video of this argument should be on YouTube if anyone wants to watch it over again. We have read the record, we've read the briefs, we've conferenced the case, so we're familiar with the record and the arguments that you've been making. So when you come to the podium, just start your argument. Counsel, you may begin.
May it please the Court. My name is John Doran. Seated at counsel table is Matthew Hesketh. We're from the law firm of Sherman & Howard, and we represent the City of Phoenix. Your Honors, I hope to cover 4 basic points this morning, time being considered. I may not get to all 4, of course. My first point is that the trial court improperly applied 12-341-01 to this case because this case is not an action, quote unquote, arising out of contract.
And MOU is not a contract?
Pardon me?
An MOU is not a contract?
The MOU is itself a contract, Your Honor, absolutely correct. But the initial question is, does this action arise out of contract? And we believe the trial court was wrong in determining that it did, in fact, arise out of contract. The second...
The city was going to amend the MOU on its own, and the firefighters contended that would be a breach of the MOU. So that's not arising out of contract because they sought declaratory judgment against you, correct?
That's correct, Your Honor. They actually sought 5 different types of relief in the case, including a declaration that we would be in breach of contract. The problem is how the case was procedurally postured. In this particular instance, we never got to a determination of a breach of contract in the first place. Because the trial court eventually threw up its hands and said the breach of contract claim, literally in the judge's words, are some other judge's problem, there was never an adjudication of the actual breach of contract claim, nor were we entitled to assert and litigate our defenses to the breach of contract claim. I have not seen an opinion from this court or the Supreme Court where a court held that where a court never even gets to the breach of contract claim or allows the other side to defend it, but instead dismisses the case and issues a declaration that doesn't touch the contract, that somehow is a case that arises out of contract.
Well, what was the basis of the trial court's ruling on the declaratory judgment action then?
The trial court's ruling on the declaratory judgment was a purely procedural issue, and it could have occurred with or without any contract whatsoever. It could have occurred in the context of a labor case or any other kind of case. The court simply declared that the decision in the Cheatham case could not impact non-parties to that case because Judge Cooper in the Cheatham case did not have jurisdiction over those parties. That is a procedural issue. At the end of the day, we could have walked out the door once Judge Duncan entered her judgment and unilaterally changed the contract. Judge Duncan never said we could not do that. All Judge Duncan ruled, and it was very specific, was that the orders in the Cheatham case do not bind Local 493.
So what happened to the rest of the case then?
The judge basically said, and I urge you to review the transcript from April 9, because Judge Duncan says over and over again, the breach of contract claim is not ripe. I'm not going to get to it. That is, quote unquote, some other judge's problem. And so the judge
How do
said,
you dismiss a case with claims hanging?
the judge simply said, I'm dismissing the rest of the case other than awarding this declaratory judgment that says nothing other than Judge Cooper's ruling in the Cheatham case does not apply to Local 493.
And you, at least at that point, you didn't take further action to change the MOU, and didn't the MOU subsequently expire?
There were a period of roughly 4 more weeks after the judgment, Your Honor, and there are 2 ways to look at that. One could say we took no action, but I believe we actually did take affirmative action, and it's as follows. Much as Local 493 argued that the Cheatham case only covered the parties before it, that would be the same in this case. Judge Duncan's ruling only applied to Local 493, not the other stakeholders. The city made a concerted decision to honor Judge Duncan's decision with respect to all of the stakeholders and not impose those unilateral changes in the interest of moving the bargaining process forward for the upcoming Memorandum of Understanding. Your Honors, again.
And so it doesn't, a party's not successful when they, through litigation, put the other party in the position that they wanted them to be in.
I frankly do not believe, Your Honor, if you look at all of the 5 forms of relief requested, that they were put in the position they asked to be in.
Well,
They avoided these changes, didn't they?
For 6 weeks. And they didn't get a final judgment that would avoid that going forward. And in fact, Judge Duncan said, you all do whatever you want to do going forward. That is your problem. There were 5 sources of relief requested in the complaint. A declaration that release time does not violate the gifts clause of the Constitution, a preliminary injunction, a temporary injunction, a declaration that Judge Cooper's ruling doesn't apply to Local 493. They only got one of those forms of relief, and it wasn't contractual in nature.
Well, but the firefighters succeeded in preventing the city from unilaterally amending the MOU, correct?
They did for 6 weeks by virtue of a temporary restraining order.
But just as you said, all we're concerned about is in this case. So in this case, haven't they succeeded?
They did not succeed because all they obtained was a temporary restraining order.
But, well, so they succeeded for 6 weeks at least.
They obtained, and yes, they succeeded for 6 weeks at least. I can't debate you on that.
And what happens after the 6 weeks is in another case, in another matter.
Your Honor, that would be true if that's what they sought in the lawsuit. But they didn't seek an injunction for a mere 6 weeks.
Well, but is a partial success a bad thing in terms of determining whether someone's a prevailing party or not?
I think you may look at partial success to determine whether or not somebody succeeded on the merits, yes. But in this case, this partial success arose out of a temporary restraining order, a procedure under which the court ruled the very day she was faced with the issue, and it just carried over for 6 weeks. Once the court got to the merits of the case, the court decided, I'm not going to touch the merits of the case. The gist of this lawsuit, in Judge Duncan's words and on appeal from Local 493, is not the contract claim. The gist of this case, according to Judge Duncan, was whether or not Judge Cooper could bind a non-party in litigation in the Cheatham case.
Now, Counsel, I seem to recall an opinion called North Point, which Judge Winthrop and I disagreed, And the Supreme Court agreed with Judge Winthrop, and I think the gist of it was that you move the other party to where you want them to be, even though you don't have a determination on the merits. That was a offer of judgment issue, but that was a sufficient determination on the merits to give sanctions relief to the party that got the other party moved into the situation they wanted them in.
Your Honor, I'm familiar with North Point, and obviously two of you know it far better than I. But I think it's distinguishable because it was an offer of judgment case, but more to the point, there was success in the context of the claim itself. This was not success in the context of the claim itself. It was success on a procedural issue that the very first day we walked in the courthouse, we said we agree with. We absolutely agree that the Cheatham Court far overreached its jurisdiction in applying its order to all stakeholders. That was never a disputed issue. To then conclude that Local 493 is the successful party for having prevailed on an issue that we never contested, and that being the only issue they prevailed on, does not make them the successful party, Your Honors.
Forgive me for being dense. I certainly can be, but the city was going to amend the MOU unilaterally. The city the union took the city to court to prevent that from occurring. That did not occur by court order. So I would think that seems to count as a success.
Your Honor, I think it is at best a Pyrrhic success and at best a partial success. They delayed what could have been the inevitable for a mere 6 weeks. They did not get a declaration on the gifts clause. They did not get a declaration on the breach of contract issue. They did not prevail on a breach of contract issue. All they prevailed on was a procedural order, and that procedural order was one we would have stipulated to the day we walked into the courthouse.
So the law, as you understand it, then, is that to be a prevailing party, you must prevail on the substance of your claim and not merely in preventing the other party from damaging you. Is that the law?
I think in the unique setting of this case, that should be the law, Your Honor, and here's why. If every time somebody ran into court and obtained a TRO, where the judge has no time to assess the case, no time to evaluate positions, but simply looks at the pleadings and determines there's a likelihood of success on the merits based on an hour's review of pleadings and grants that relief, and that's the only relief you get during the currency of the case, and then the only relief you get is a non-contested issue, that's not success. They are not the successful party, and it's still not an action that arises out of the contract. If I may turn to my second point, Your Honors, putting aside whether or not the trial court properly applied 12-340-101, we firmly believe on this record that the trial court abused its discretion in light of the very unique factual setting we're looking at. For starters, there was no evidence or argument at all that the city somehow jumped on Cheatham as its opportunity to divest all the stakeholders of release time. Release time has existed in this city for 30-plus years. The city was simply reacting to an order from a court with which it disagreed and with which it took up an appeal, and tried to incorporate that for fear of contempt sanctions. The city did everything in its power to minimize the impact on Cheatham with respect to the stakeholders. The city didn't ask the Cheatham plaintiffs to file that lawsuit. The city didn't ask Judge Cooper to issue as broad an order as she did issue, covering all stakeholders rather than just the actual union that was in the plea case. In fact, the city tried as hard as it could to minimize the impact. The day Cheatham came down, the city tried to open negotiations with all stakeholders. The city then gave everybody an extension of time in which to consider whether or not they could agree with the city's interpretation of Cheatham and how the city intended to roll it out. The city appealed Cheatham. The city even went back to Judge Cooper and said, Your Honor, with respect to Local 493 and others, Please tell us what you mean. Do you really intend to cover non-litigants as part of your injunctive relief in this case? And Judge Cooper said absolutely yes. The city's hands were 100% tied. Does the city engage in contumacious behavior by saying, I'm sorry, Judge Cooper, you entered an injunction, we are simply going to ignore it? If there was ever a definition of the word whipsaw, that's what happened in this case. We were literally running between Judge Duncan's court and Judge Cooper's court, where we had two Superior Court judges who disagreed with the authority of each other to make decisions affecting non-parties. Even though we agreed wholeheartedly with Judge Duncan that Judge Cooper was wrong in making decisions with respect to non-parties. And I think the important point in terms of the court's clear abuse of discretion is to try to reconcile what the trial court did in this case with the trial court's own factual determinations on the record. Here are just some of the things Judge Duncan said to us on April 9th and on June 16th during the attorney's fees argument. Quote, the city is definitely in a difficult position, end quote. Quote, I don't envy you, end quote. Quote, this is unfortunate for the city, end quote. Quote, it's more than unfortunate, it's extremely uncomfortable, end quote. And that was not a lie. It was extremely uncomfortable. And probably the most important quote from Judge Duncan was her recognition that our reading of Cheatham was not meritless. It's not like we took it and went on a rampage to get rid of release time. Judge Duncan said, I see where you're coming from. I see how you could read Judge Cooper's order and conclude that Judge Cooper thinks you have to cover all stakeholders.
Well, Counsel, I understand your argument. I understand what you're saying. Question I have is, I understand your motive. Let me rephrase. I understand the city's motivation for trying to comply with Judge Cooper's order. But how does the motivation for taking action affect whether a party is a prevailing party or not in the subsequent action?
The point, Your Honor, is that the trial court clearly abused its discretion when it made the factual determination that all of this was because of the city, rather than because of the Cheatham orders and the predicament that the city was placed in. That is clearly erroneous, Your Honor.
The city could have chosen just to sit tight until the Cheatham matter was resolved.
Your Honor, I don't believe that under the law the city was empowered to ignore injunctive relief from a judge of competent jurisdiction. That was not an option. We could not just sit tight. The judge ordered us to go back and review every MOU and see if it complied with that judge's order. Whether we liked it or not, that was our legal obligation. We could not properly engage in contumacious behavior. And for that reason, Your Honor, we were caught between the Scylla and the Charybdis. We had no choice. And the trial court's determination that this was the city's fault is clearly erroneous and a clear abuse of discretion. Thank you.
Counsel? And Counsel, can you address how the issue before this court is affected by the city's position that the city was stuck? It had to do what it was. It had to do what it did.
Yes, Your Honor. May it please the Court, Rupali Desai, on behalf of the Phoenix firefighters and Pete Garais, and some of the members of my client are here with me today. You raise a very good question, and one that should be addressed, because throughout at least the most recent arguments that the city is making in this case is that it's been stuck between a rock and a hard place. But Judge Duncan heard this argument. She considered this argument and gave it the weight that it deserved, and ultimately deciding in her discretion that fees were warranted in this case. In fact, the city is not saying that Judge Duncan abused her discretion because she didn't recognize this predicament to the extent it even existed. And I will talk in a moment about how we don't believe, in fact, that the city was between a rock and a hard place. But they're saying that Judge Duncan agreed with us. She made the correct factual finding. She said, in fact, that maybe the city was in a difficult position, but even considering those arguments and the potential of difficulty, I view the city's decision in this case to unilaterally apply an injunction that does not involve and does not relate to a contract that was not before Judge Cooper to another contracting party to be unreasonable. And from the very beginning in this case, from the time that Judge Duncan entered the TRO to the time that she denied the city's motion for reconsideration, to the final ruling in this case where she awarded declaratory judgment to the firefighters, Judge Duncan's position was clear. Judge Cooper's ruling cannot and does not bind parties that are not before her. On the issue of whether or not the city was in fact between a rock and a hard place, I think it bears mentioning that until recently, and early on in the case, the city was arguing over and over again that in fact it did believe that Judge Cooper's ruling applied. And we cite in the index of record cite is 4142 at page 10, and we list several examples of the city's arguments that Judge Cooper's ruling should and does apply to parties that are not before her. They said, plaintiff now argues that Judge Cooper lacks authority to extend the permanent injunction to it as a non-party. Plaintiff is wrong. Also, the city says, Judge Cooper's permanent injunction plainly applies to the Phoenix firefighters' MOU. It was not as if the city was taking a position that was consistent with the firefighters. It was trying to implement Judge Cooper's ruling beyond what Judge Cooper intended. And we submit to this court, and it's in the record, that the city basically did not want to honor its contracts with various other bargaining units and jumped to action when it received Judge Cooper's ruling in the Cheatham case to try to apply it unilaterally to other unions. I also want to read for the court the language in Judge Cooper's ruling. The city continues to argue today, as it has in its papers and as it argued to Judge Duncan, that its position was reasonable to extend Judge Cooper's ruling because her order clearly mandated that the city extend the injunction to parties that were not before her. Her orders say exactly the opposite. Her initial ruling, which is Index of Record 1, Exhibit B, says at the very end, finally, at trial, evidence was presented that the city had MOUs with other unions. While these MOUs are not before this court, the law regarding city-funded release time applies. The city should review its MOUs with these unions to ensure that they are consistent with this court's ruling. Judge Cooper does not tell the city of Phoenix to go extend her injunction to other MOUs. It asks them to review them. What the city did was turn around the next business day after receiving this order and tell other bargaining units in the city of Phoenix that it will unilaterally alter their contracts based on the language in Judge Cooper's ruling. Then, when the city went and sought clarification from Judge Cooper, and I will note that that occurred after this litigation was filed, they went to Judge Cooper and asked, and Mr. Doran said to the court today that Judge Cooper's clarifying order said that we must go extend the injunction to other MOUs. Judge Cooper's ruling says, the city asks the following question: must the city apply the same legal standards to all bargaining units with respect to the release time specifically enjoyed by this court? That's a different question than should the city go and bind other MOUs to the same ruling in Cheatham. And the court says, the court specifically enjoined the city's release time agreement with plea because the plea MOU was before the court. She goes on to say, the court advised the city to do that, to review its MOU contracts with its other unions, but also says the court made no determination as to whether the city's contracts with other unions are in violation of the gift clause because those contracts were not before this court. my point in reading those excerpts is to make clear that the city, on its own volition, decided to extend Judge Cooper's injunction ruling to other parties that were not before her. The single issue on appeal before this court is simple and straightforward, and that is, did Judge Duncan abuse her discretion in awarding attorney's fees to the Phoenix firefighters under 12-341.01? Put another way, did Judge Duncan have no reasonable basis whatsoever to award fees, or this court can decide that Judge Duncan did have at least one reasonable basis to award fees? And if the answer is yes, and we would submit to this court that the answer is a resounding yes, that there was any one reasonable basis for her award, then this court must affirm the trial court's award. What is particularly ironic about the city's appeal of Judge Duncan's fee award in favor of the firefighters is that in some ways it's the best example of why fees were warranted in the underlying action and why fees should be awarded on appeal. They did not argue in their papers, and they have not argued today, that there is no reasonable basis for Judge Duncan's ruling. In fact, Mr. Doran argues that the trial court improperly applied 12-341.01, an argument that was not even raised in the trial court. In fact, the city filed a dueling fee application under the same statute, arguing that it should be entitled to fees in the trial court. Also, Mr. Doran argued today that Judge Duncan abused her discretion because they disagree with how she ultimately concluded about their position. But disagreeing with Judge Duncan, or even demonstrating to this court that reasonable minds can differ about the outcome, is not the same as being able to prove that there was an abuse of discretion, that there is no reasonable basis for Judge Duncan's award of fees. And the city has advanced these arguments time and again, and in this appeal, despite the clear standard for an appeal of attorney's fees that's been set forth in dozens of cases and opinions rendered by this court. The city asked this court to reweigh all of the evidence that's been presented to the trial court and to conduct a de novo review of the issues because it doesn't agree with Judge Duncan. Again, the city's mere disagreement or belief that she should have ruled differently does not justify reversal of Judge Duncan's order.
What about this argument that the determination of this case did not reflect on your contract claims, that somehow this didn't arise out of contract because the case was somehow resolved on a procedural issue that never reached the question of your client's contract rights?
Judge Thompson, thank you for your question. I think that your question earlier to Mr. Doran was exactly right. That is the standard in Arizona, which is, did the party prevail in achieving the result that was sought when filing the lawsuit? And North Point addresses this, as well as Nickerson versus Green Valley, which is a Division II case, and most recently Fulton Homes v. BPP Concrete, which is a case that came out of this court, where the court explains that you don't need to prevail on all of your claims. And in fact, we argue that we did prevail on all of our claims. We went to court seeking a temporary restraining order, which we got, and a declaratory judgment that Judge Cooper's ruling doesn't apply to us. We also prevailed on that point. The other claims that we brought were in the alternative, and Judge Duncan correctly decided that she didn't need to reach those points because she resolved the main issues in the case and the ones that provided us the relief that we were seeking.
Well, and counsel, if Judge Duncan agreed with you on those grounds, then that's the end of the matter as far as you're concerned, and whatever else would happen about the constitutionality of release time is a different case at a different time. correct?
That's right, Your Honor. It's a different case for a different time. Also, in addition to that, there were, and I think you asked this question early on, there were no changes that were made for the life of the MOU. It was not our preference to go to court to seek a TRO. We were telling the city from the very beginning that this is a short period of time left in this MOU. Let's not expend resources and time litigating this. The fact that there was only 6 weeks of relief that we were seeking left to obtain is not because we were granted limited relief. It's because that's all that was left on the life of this particular contract that we were forced to have to go to court to protect our rights under. I want to point out language that Judge Duncan used early on in this case, and it goes to the issue of the reasonableness of fees and the unreasonableness of the city's conduct throughout this litigation. Judge Duncan indicated this was on the city's motion for reconsideration. This is the March 20th, 2014 hearing transcript at page 14, lines 8 through 18. Judge Duncan asked, "Why isn't everybody just devoting energy to negotiating a new contract, ? And stop this litigation and hemorrhage of attorney's fees? That makes no sense from a risk management point of view. Mr. Dorn, I'm looking at your client right now. I cannot understand in a million years why attorney time is being consumed in this court on this issue." And yet, even after Judge Duncan signaled that there was no good reason for the city to continue in its quest to basically force the firefighters to expend more time and more resources, and frankly to leverage itself in the next bargaining cycle with the firefighters, they continued to do that, and Judge Duncan, in her discretion, decided to award fees. The city has not identified any of those fees, did not in the trial court, and has not been able to show this court why Judge Duncan's award of fees is an abuse of discretion. Unless the court has any questions, I will rest.
No. Thank you,
Thank you.
counsel. Counsel.
Thank you, Your Honors. First of all, I'd certainly invite any questions before I wrap up.
Well, can you explain, if this is not a contract action, how you ask for fees?
Your Honor, at the trial court level, I think that happens all the time. We're not precluded from arguing that it's not arising out of contract. And by the way, the notion that we didn't argue this below is untrue. Our motion, or our response to their motion for attorney's fees at page 2 begins that very discussion. Our point is different in that a party who defeats a contract claim or prevails as a defendant in a contract claim may acquire fees under ARS 12-34101. The inverse is not true. That is, a party who brings a contract claim and does not obtain contractual relief is entitled to attorney's fees. They're not one and the same. We essentially defeated a contract action. Going forward, we were free to make unilateral changes. We didn't. And to punish the city for making a voluntary decision not to implement unilateral changes going forward seems to me to be not only counterintuitive, but a clear abuse of discretion.
Well, and the other question that today's argument has raised is, if you read the language of Judge Cooper's order, and then when you return to Judge Cooper, he doesn't, I don't read the language that the city is to review the MOUs with other unions to be a directive to unilaterally change the MOU. That seems to be a voluntary action the city took. The city might be between a rock and a hard place, but it seems like it put itself between a rock and a hard place.
Your Honor, with all due respect, nothing could be further from the truth, and I urge all of you to please review both of Judge Cooper's orders verbatim. Ms. Desai just read you...
I was on the appeal in Keyham.
Pardon?
I
know you're very familiar with them, Your Honor. Ms. Desai only read you a part of those orders. The order concludes that nonetheless, the city is instructed to review all of its contracts and to make sure they comply with this order. So yes, Local 493 was not bound by that order, but yes, Judge Cooper at the very same time was saying you have to do this with respect to everybody, including Local 493. To suggest that Judge Cooper said, oh, my mistake on motion for reconsideration, I did not mean to bind non-parties, is completely disingenuous. Judge Cooper's order couldn't be more clear. She specifically said, when you go back to the drawing room, read every one of your MOUs, I expect the city, regardless what the unions want to do, I expect the city to respect and follow my order and follow all of the standards I have set out.
Thank you, Tim.
Thank you.
We appreciate today's argument. We'll take the matter under advisement and issue a decision in due course. We stand adjourned.
As soon as we're done, it's